The full title of this Texas Penal Code statute is unlawful disclosure or promotion of intimate visual material, but it's easier to call it by its informal name, the revenge porn law. The availability of technology has allowed consenting adults to make videos or pictures of each other in sexual situations. Problems arise, however, when the relationship ends and one party, who received or made the images with consent of the other, posts them on the internet or on social media without the other person's consent. While this kind of act could only previously be regulated with a civil tort lawsuit, the 84th Texas Legislature made it a criminal offense. First, the Penal Code states a person commits unlawful disclosure or promotion of intimate visual material if they, without effective consent and with intent to harm, discloses visual material of another with intimate parts exposed or engaging in sexual conduct created under circumstances in which the actor knows or has reason to believe the other person had a reasonable expectation the material would remain private. In addition, this exposure must cause harm and reveal the identity of the person through essentially any means. Next, the Penal Code states a person can commit unlawful disclosure or promotion of intimate visual material if they attempt to blackmail another person by threatening release of the intimate visual material. Or finally, a person can commit this offense by operating a website or other similar forum that promotes revenge porn. This is a screenshot of one such semi-famous revenge porn site which falls under this conduct. The site is no longer online. The Penal Code states it is not a defense the visual material was created with consent or the victim voluntarily transmitted the visual material to the actor. So in other words, just because your significant other consents to creating the images or video or sends them to you doesn't mean they automatically consent to you transmitting it after the relationship ends. It is an affirmative defense the disclosure of the intimate visual material was part of a law enforcement investigation, medical treatment, or a legal proceeding. It is also an affirmative defense the disclosure of the intimate visual material was in the course of reporting unlawful activity. So, for instance, the video or images were made consensually, but the disclosure occurs in order to report statutory rape to the police, and the video or images are evidence of that offense. It is an affirmative defense the disclosure of the intimate visual material was made in a public or commercial setting and involved voluntary exposure or sexual conduct. So two people can't make a video, both consent to its release, and then one of them later have second thoughts and try to pursue criminal charges against the other. Finally, it is an affirmative defense the actor is an interactive computer service. All of the offenses under the revenge porn statute are state jail felonies.